I did.
And there we
are. We're live. We're early.
We're
way early. It's 6:29. Oh, now 6:30.
There you go.
I hope for all of you out there who enjoyed that extra segment, we thank you very much. We appreciate your attendance.
You missed it. We had some real earth-shattering knowledge there that we talked about. So,
yeah, apparently Mr. JR just discovered that there's wine country in California. He didn't know that.
I had no idea.
Well, isn't that amazing? What a coincidence. So it's just to kind of put everybody in context. It's Mr. JR and not legal advice. And this is not legal advice. This is just put out there. You know, when people say entertainment value, you know, they say that. I think about that. Somebody puts out this big, like, you know, I'll talk about a case for 25 minutes. Is that really entertaining? I don't know. Well, so I'm not going to say it's, I'm sorry, go ahead.
We throw in the entertaining parts in between all the serious talk. So.
Yes. But I hear it. It's like one of those, you know, if you look at the taglines that people have after they start their videos, don't rely upon this, etc. This is entertainment. I just find a lot of it is not entertainment. So I object to that characterization.
Some of it's sheer boredom, to be honest with you.
Yeah. And I'm probably responsible for a good amount of that, just to be clear.
Speaking of that, someone actually said on William's live stream that your jokes suck.
I heard that. I appreciated that too, honestly. You know, listen, if you get a response, that's good enough, good, bad, or indifferent. You know, last week I was thinking, you know, it's pretty interesting, and we'll get to it. Last week we did ham and cheese, if you recall. Yes. And this week we're doing prehistoric salami. And, you know, there was quite a demand for that topic. And, you know, I'll get into it. I'm going to put it in context when we get to it.
Barbara says someone's waiting for us to dance and sing.
But well, maybe later. Maybe later. Maybe
you got to be on mushroom space if you want to hear me sing. This is the serious place, okay?
Maybe if we're on here long enough and JR can get into enough glasses of wine, we can get there. Maybe. I don't know.
This is the second one today, but my first one was like 3 hours ago. So
okay. So we're going to discuss a bunch of things. I'm just going to lay out what we're going to discuss, and we'll see what else comes up. By the way, I am super excited. I told JR I'm super excited about tonight because I think we're going to talk about stuff that isn't really talked about and is really relevant to what we're experiencing.
Exactly.
Besides other stuff that I think is interesting to whoever's watching this or will be at some point. So we're going to talk about, in part, Alpine, Finger, MMTLP, Goldman Sachs, Citadel, SEC, Tesla, and of course, prehistoric salami.
Well, yeah, and let's do that one first because I'm a little confused. What? I mean, salami is a cured meat.
Yeah, I know. I know. And I will get to that very shortly. But I kind of wanted to, behind the scenes, I want to kind of say behind the scenes. What we do is I kind of basically prepare the agenda. JR sometimes contributes too. I always ask him, and he does at times do that. But basically, I send him kind of an agenda that we're going to do that night. But sometimes I omit items. Like, for example, I always omit the purported jokes. I always exclude those. And sometimes, you know, like prehistoric salami, I didn't pass that on either. So sometimes when he comes on, just to be fair to him, he doesn't have the full picture. And I think it's more fun that way, by the way. So that's why we do it. So now we've disclosed that important
just
thing.
One comment. I just want to let everybody know that when we first started this, I was lucky if I got the topics 2 to 3 minutes before we started. And as we progressed with kind of our Sunday night chat here, it would get further out. You know, now I actually get them on Saturday, but truth be told, I don't look at them until like Sunday midday. So
yeah, I thought you looked at them after we finished. That was my impression, but who knows? So I'm going to get to the prehistoric salami again. So the summary is, I'm sure we all know about the feral pigs in ancient Mesopotamia. They, the descendants of the Egyptians, and who many suspect were the first aliens, roamed the earth looking for pigs and new delis to facilitate the consumption necessary to yield victory. King Ramses XII is known by most as being the first creator of lunch meat and set up a series of sandwich shops throughout the Egyptian desert. I hope that clears it up. Everybody now knows.
Now we know.
That's it.
Prehistoric salami, ladies and
prehistoric salami.
Ramses.
Yeah. So before we begin the other topics, just a quick throw out. The past, present, and future walk into a bar, and it was tense.
They're just so stupid.
And just to see if we could top the first one, shopping centers. You've seen one, you've seen them all. All right. So,
oh my God.
All right. So we'll see kind of where this goes tonight. We'll go through our stuff, but I started on Alpine. I don't know why I picked that as a starting spot. People ask because it's an unusual. So this is GTII. It's unusual, and by the way, I find that the two topics that we're going to discuss later on, including the Uptick rule and share lending, I think are going to be tremendously interesting. Thank you very much. Thank you very much.
Yeah.
Keep going. Alpine status is, because people ask because they're wondering what's going on with Alpine, and the appeal is still ongoing. I would say within the next week, FINRA will be filing their brief.
Right.
And at that point in time, the appeal will have moved farther along. But people really shouldn't expect that process to move in a quick way. Still may take months. If in fact that's important to GTII, and some people believe that if Alpine goes down, that's important to GTI, that will encourage a squeeze. We don't know. And by the way, not financial advice. I know I said not legal advice.
Well, you got two other things going on too. Because I saw someone had asked about what was going on with GTII's lawsuit. And, Wes had filed an amended complaint last month. We have copies of that amended complaint, but I can tell you it's like 50, 60 pages. And I took a look at it the other day, but I mean, it's a lot, especially on your phone. That's the type of document you need to print up. So and sorry. And the way it came about was he filed and this is federal court. He filed an original complaint before the defendants can file a motion to dismiss. They have to meet and confer, which means they actually have to communicate, and they have to present what they think the deficiencies are in the complaint. They did that to Wes as opposed to fighting the motion to dismiss, which, probably not worth the battle. He amended his complaint, refiled it, and now that's where we are in that particular scenario. My guess is, even though I don't know the other attorneys, they'll file another motion to dismiss, notwithstanding whatever he filed, just to give a shot, and they'll see how that goes on. If generally in that type of litigation, so just kind of give you a difference. So in what I do real estate and business litigation primarily, and sometimes we go to trial because we go to trial, and that's just the way it goes. But in these securities cases, they generally don't. And it appears that the trigger is if you can get past the motion to dismiss so that now you have the right to discovery, that seems to be the trigger for initiating settlement. So that's kind of where and I'm not speaking for him, obviously, but that's where it appears that they're going. And that's the status of those pleadings. I don't think it has much impact upon the stock price of GTII. Just think it's another background things. And, we don't really know what triggers a short squeeze. We think we do, but, it doesn't happen that often, and doesn't happen to the targets that we would like it to happen often. So, but, we can point out circumstances that suggest that it may happen. And that's kind of what we did. And that's what apparently we talk with Ham, the short killer. We talk with, and who does a lot of, with regard to shorts and particular finger motion and GTI. William, who's great. Ace, we were talking about these people before, so we're not saying things we wouldn't anyway.
we all appreciate them and the work they do, and we follow them, and so we learn from them also and get all kinds
Sure.
of information. So,
Sure.
but nobody really knows.
Right. Well, it's anyone's guess. I mean, until you're sitting at the desk at one of these hedge funds and actually, are being told what to do, what to buy, what to sell. Yeah, I mean, it's just anyone's guess. It's back office stuff. We really don't know what the trigger is or when it happens or why it happens, but obviously it happens. So,
and I'm going to go to, I say this every week, so I'm going to say it again. So as to GTII, if in fact Alpine's ceasing to exist, and the story is basically that this is my terminology, it's not a legal term, but those guys are scumbags. So and they've been cited and penalized, so it's not like it's even a question. So,
well, we can legitimately say they're criminals. I mean, they've had 3 different enforcement actions against them in the last 3 years by FINRA and the SEC. So every time a decision's been made, it's been found, in the favor of the regulator. So yeah, they're criminals.
Yeah, but when it comes, I'm saying, go ahead. I'm sorry.
No, I was just going to say they are. So,
but when it comes to like speaking to people we're speaking to and ourselves, the practical outcome is much more important. So we understand that, there's a bunch of proceedings that are ongoing and FINRA is trying to shut down Alpine. And I think that's perfectly justified and should be at some point in time. But the way they're doing it is they're trying to also keep their own authority by doing it within the structure of FINRA and the SEC. Unfortunately, that's a much slower process than if they went into federal court and used the evidence before them. So again, I say it every week, but there's no reason for FINRA or the SEC not to go into federal court tomorrow on GTII and seek a receiver and basically take over the business and shut the doors.
Right.
No reason not to. FINRA has already found that the public is at risk. It really makes no sense. And kind of like, I was thinking about that, and I know it's a little off in order, but I was thinking about that, and I did a little bit of a video about that, is the recent fines to Goldman Sachs and to Citadel. I don't remember what the Goldman Sachs fine was. I'm sure it was less than $7 million. I know the Citadel fine was $7 million. And the Citadel fine, in essence, if you want to look at what it comes down to, there were some issues about shorting practices, and that's what it comes down to. Over several years, and we know, I think last year, Citadel made something like, last year being 2022, Citadel made on the order of over $40 billion. I think they were the most successful hedge fund on Wall Street last year.
Yeah. Well, what did the fine came out to? I think somebody did the math. I'm doing this from memory, but I think it came out to like $273 a trade. That's what they paid on the fine. So they paid a $7 million fine that boiled down to $273 per trade, which is just, I mean, that in and of itself is criminal.
I think that's I was going to say, I think that's conservative because I think the practice occurred over time, many years. And whatever, this is how it works. Whatever gets caught is just a small percentage of whatever happened. Right.
Yeah.
And, and how would this discourage them from doing it again? Why would they? I mean, I would think just the opposite, right? Listen, if I know that that's the penalty I'm going to face for making X billions of dollars, why not do it? It makes no sense.
Someone put a tweet out about, look, I'm going to rob a bank for $7 million, but I'm only going to pay, like $20,000 fine. Why wouldn't I do that? And that's basically what they're doing. They're stealing money from retail, and they're making 200, 300, 400 million and only paying 7 million in basically restitution. The other thing, which Ham says this all the time, and it's 110% true. They had all these trades. They broke the law. They naked shorted. They misreported, which rhymed, by the way, and they only paid $7 million. But what were the tickers that they were hitting? What happened to all the shareholder value in all those misrepresentations on their their reporting and the counterfeit shares that they flooded the market with? I mean, shareholders lost value. What are those tickers? They should be required to pay the value of the difference between what it was when they shorted and what it was currently.
Well, if you probably were a customer of Goldman Sachs, you probably could sue Goldman Sachs. If that's the case, at least to figure out, how did you figure out, what the fine was based on what? Where's the information that you base the fine on? Because it must reflect transactions at Goldman Sachs.
Sure.
And I don't know. I really don't know. It sounds like, for example, would it be? Now I was going to say that statute in New York, if that would apply, like a pre-litigation discovery statute. Yeah, I don't know. I don't really know. I hadn't really thought it through, but I don't know.
I wonder now if shareholders, but here's the kicker. How do shareholders find out what shares are? I mean, there's clearly liability there. They broke the law. So, and that's why the SEC doesn't release which ticker. The SEC should be required to release which tickers were involved. And that should then, obviously flow down to the shareholders, and shareholders should have a right of action against Goldman Sachs for breaking the law.
Yeah. I would say, this is certainly not legal advice, and I don't know if I'm going to do it, by the way. So I when I say it, and I haven't really thought about it more than 3 seconds, but I guess if I had an account at Goldman Sachs or Citadel, I would probably send a letter to them demanding the information. And then I could file an action if they didn't provide the information, because I'm one of their customers and I might have been impacted. Then I guess I could file an action against them to seek, again, for declaratory relief, just to find out, was I impacted by that? Because they won't tell me. And because we know they were responsible for misconduct, because they've acknowledged it. They had, this is not a case where there's an issue of he said, she said. They acknowledged the misconduct. Whether they say they did because the fine was so low, which would be an interesting argument to make, right? But if that's the case,
we should be able to FOIA the SEC. I mean, the investigation's over, so they can't claim 7E or 7A. So we should be able to FOIA the SEC for all the investigation documents related to the settlement against Citadel.
Probably should ask.
Why wouldn't we be able to?
Yeah, we should ask, and we based on our limited experience with the FOIA process, my guess would be they'll deny it on a whole bunch of exemptions that, unfortunately, a lot are not applicable, really.
No.
And then and I think you are in this spot, then there'll be appeals filed, and they'll probably deny those also. I'm predicting they will deny those. Maybe we'll be lucky, but it seems like they're not trying to be too open about the process. And then if you want to proceed from there, you'll have to file a FOIA lawsuit.
Have to file a FOIA lawsuit. Right.
Yeah. And I guess, the strategy would be for them, I don't know this, by the way, to be a fact, but they must think that by the time you got to the conclusion of your FOIA lawsuit, if it were not appealed, that the issue that you were bitching about would have passed. And I think that might be their strategy, something ridiculous as that.
Well, they're counting on no one going into federal court. That's what they're counting on. So they're counting on people filing these appeals, getting denied, or filing their FOIA, getting denied, filing an appeal, getting denied, because now the next move, once you've exhausted all your administrative remedies, which that's what you need to do, you then have the right to go into federal court. But that's costly. I mean, you have a filing fee, you've got to get an attorney, you've got to draft all these documents. But what people don't realize, and you and I talked about this before, FOIA is a little different. FOIA is a unique law. When you file a lawsuit under FOIA after you've exhausted your administrative remedies, the burden shifts. The burden now shifts to the government to prove that they've met the exemptions under FOIA, which the 9 exemptions. And so the burden then shifts. So basically you put your complaint in, the government has to respond. Now the government has to prove through testimony and documentation and witnesses that they've met the burden under the exemptions. So, one of the pieces of research that I found, which It's laughable that they're even using exemption 6. Exemption 6 basically says we're going to deny it because it's personal information and it could be damaging to the individual that's in the request. It's a bullshit exemption, because what it really deals with is personal information of the individual that you're requesting about and or medical records. Well, in my FOIA request, I didn't request any specific information related to a person, so I don't know how in the hell they're even using that as an exemption. It's again, they're throwing the kitchen sink.
Okay. I don't disagree with you. I think it's in bad faith, but I think they believe they're running out the clock, really, as I think that's a strategy. I think that's the government strategy a lot of times, because they know that most people will unfortunately fall by the wayside,
Right.
Just like, if we're talking about MMTLP, I was thinking about this. It always has struck me as interesting that there were basically maybe 4 lawsuits that were filed, maybe 5. They were all lawyers, right? So they all could do it without, they're obviously speaking from personal experience. Obviously, there's cost and time, etc. But you have the ability to do it without incurring, a $250,000 debt in legal proceedings. But there haven't been a lot beyond that. And I think I thought this was remarkable. As far as I know, I'm the only arbitration.
Well, I think you're the only one that's been public about arbitration. I mean, I don't know of anybody else, I freely admit, but you're the only one that's been public about your arbitration.
And the reason why I'm suspecting that there's no others, because if I was because I've been pretty public about it, right? So if you were interested in finding out, is there another matter pending in arbitration involving MMTLP, I think you could easily locate me. And if I was plaintiff's counsel, this is why I think that. If I was plaintiff's counsel on another matter and there's some guy who's a loudmouth who's talking about this stuff a lot, I would at least make a call and say, what can you tell me about what's going on, how they're reacting, etc. So that's why, one, I haven't seen anything at all, and nobody's contacted me or tried to reach out to me. So even if there are, let's say, I don't think there's a ton, no matter what, I don't think there's like an abundance of those. And it's kind of surprising to me. Maybe that will change in the future. Maybe it won't. It just kind of reflects how, kind of what you were saying, kind of reflects how difficult it is to get to that spot. And that's kind of what they're hoping, that there's enough people that won't do it.
Right. Well, it's a lot of time and effort. I mean, you have to go through the filings, you have to figure it out. I mean, look, let's be honest with the people that are listening. I mean, filing an arbitration is not that simple. I mean, you're constantly calling me to bounce ideas off me, and I'm not bragging. I'm not trying to make myself seem.
You shouldn't brag. Why is JR bragging? Why is JR always bragging?
What I'm getting at is it's a lot of work. It's a lot of work for someone like you who's experienced. You still need some level of help. Okay. But for a non-lawyer, for someone that has never done this before, it can be overwhelming. It can be scary. And they're banking on that, and they're banking on not, people not wanting to get an attorney and having to go through the process, people not wanting to have to file an arbitration because they've never done it before. That's part of how they're approaching this. It goes back to the cost benefit analysis of Ford Pinto. That's what it goes back to. That's what these guys think about.
Yeah, which to speak in English, what that means is when the Ford Pinto was a Ford model way back, I think in 1849, when JR was about 13. And what happened was, unfortunately,
you would have been in law school when the Pinto case was being talked about, right?
No, I just started Social Security, I believe, at that time. So it turned out, unfortunately, the Pintos, when they were hit in a particular way, they would explode. The gas tanks would explode, and it really became a big issue. So there was litigation that ensued, and this is one of my favorite stories because it reminds me of Howard MMTLP. During the litigation, they had, we've heard about discovery, what that is. So during that discovery process, there was an exchange of documents. And in the exchange of the documents, some attorney from Ford inadvertently, and I put that in big quotation marks, sent over a memo, an internal memo that where they had basically, they were aware of the potential of the fires. They were aware and actually had calculated what the prospective damages would be and the number of victims. And in the end, and they also compared that to how much it would cost them to change the gas tank. And in the end, they figured out it was cheaper to pay out those people that ended up suing for really serious injuries or deaths versus making that change. And that memo came out during the case. And obviously it was, it changed the outcome of the case dramatically.
And so you all know it was such an impactful case in terms of how corporations view issues like that. It's still discussed in law schools today. Now, I was in law school back in 2003, 2002, well, 01, 02, 03, 04, and we talked about it. We talked about it in two different classes. So it's a seminal case in terms of cost benefit analysis, from a litigation standpoint. But that's what these guys do. That's what they're doing. They're looking at what's the cost of litigation versus what's the cost of some level of settlement. And they're not expecting us to take the litigation route. Not that I'm insinuating or implying anybody should do that. We're merely having a discussion.
Yeah. For most people, especially if I was thinking about that, I may have talked about this at some point in time. It's possible for somebody to do it. It's possible for somebody to handle their own arbitration. And probably it's possible for some people that are adept at it to win an arbitration, but probably for the large majority, it would be an overwhelming experience that in the moment, because you could prepare for something, you could think about something, but it's like anything else. If I went up to bat against some right-handed pitcher throwing 100 miles an hour, I would really not be thinking very clearly, even if I had prepared myself properly. And, it can be really overwhelming. And so I understand why people don't do it. So it makes reason.
Right.
Listen, that's why I, it's no secret. That's why I'm doing it.
What have I told you right from the start? Since one of the very first conversations we've had, what did I say to you? Do you remember? Do you want me to repeat it, or are you going to?
No, I'm not going to repeat it. I don't repeat those things. You can say it though.
I'll repeat it for the audience.
Say it again. Go ahead.
A lawyer that represents themselves has a fool for a client.
Yes. And there's of course exceptions, present company, of course. And I've been clear that, I've been clear about it, that I see my representation and my involvement different than if I was representing a client, an outside client. And in particular, I see this as different. So I understand.
And just so everybody knows, that this just popped into my head. I want everybody to know, when I talked to Rosa back, I want to say in January, and I told her the same thing. And I also had a conversation with Hands of Steel and told him the same thing as well too. So I don't want anybody to think I'm talking out of pocket, because I've had those conversations. In fact, I think I might have even told Alan the same thing. So
yeah, just so you know, I try not to handle one. I try to avoid legal disputes because I get involved in enough of them. How much fun is it to do on your off time to do your work where somebody's yelling at you? It's not a whole bunch of fun. So I try to avoid it, but I've had, it's generally difficult because it's hard to stay objective. You get too personally involved, but the times that I've done it myself, I've been pretty good at it, and my results have been pretty good. So, but I don't even put this in that category.
I did it one time and I got my ass chewed out by the administrative judge for doing it, and I never did it again.
And you probably deserved it.
I did, because I was a cocky young lawyer, and so one bitter taste in my mouth.
But one fundamental difference, I'm not a securities lawyer, but we've learned a lot, by the way, over this past year. We've learned a lot of securities law, JR and I, and a lot of other people. And the other thing is that do litigation. So I do trials, and a lot of times the security stuff don't even go to trials. So in terms of my comfort level in the dispute part of it, I'm perfectly comfortable. And that gives me some advantage. But I agree that in general, it's a bad idea to represent yourself, and you should if you can. If you usually a financial issue, if you can't, for an average person. So, but anyway, that's kind of what's going on with. We were talking about Citadel and Goldman and the fine and all that nonsense. But everybody figures, oh, I know what I wanted to ask you. I threw this out before, and you could not answer it if you don't want to answer it.
Sure.
You wonder why somebody because I don't think the SEC really wants to punish these parties. Doesn't seem like it. That their actions don't really support that. Do you think it's a straight? I mean, what do you think? Let me ask it a more open-ended. What do you think is the reason why they don't enforce these type of penalties more stringently?
I mean, I hate to say it because I've never felt like I was a, government corruption, government conspiracy type of person, but I think the SEC looks at this, and I'm gonna use Gary Gensler's own words in front of the Senate Banking Committee last week. He said it multiple times, and I'm sure you're going to hear it this week. We try not to talk about our investigations because of the disruption it does to the market, and so we've had these conversations on Spaces. I'm going to use MMTLP as an example to talk about to answer your question. Well, imagine if the share count came out. Let's go back to Mark's filing in New York is actually a better example. And we talked about this on one of your YouTube channels back when Mark's case was still in front of the New York State judge. Imagine what would happen if Mark's petition would have been granted. Every one of these tickers, it would have been a floodgate. The floodgates would have been open, and every one of these tickers would have been filing for a prediscovery motion for, to get the blue sheets for their own ticker. And so I think part of why the fines are what the fines are, and part of why they don't release the tickers is because, this segment of retail that we're all involved in, whether you're MMTLP, GTII, Finger, that one we talked about last week, or Vocal or CLVN, any of the ones that Frank talks about.
It was ASRE.
ASRE. If they start releasing tickers and start to say, yeah, Citadel naked shorted, SUCK company. Well, we're going to know. We're going to know all the things that we've speculated is 110% true. And that's going to be a disruption to the market. And so, whether it's right or wrong, and I do agree it's wrong, it is what it is. They should be disrupting the market because right now the market is in desperate need of a correction. And it's in desperate need of a correction because all the crime and fraud that's been going on. Obviously, though, Gary Gensler's not going to do that. And again, going back to his own words in front of the Senate Banking Committee, we don't confirm or deny investigations because of the impact it can have on the market. Well, that's just fucking nonsense, to be honest with you. And he should be talking about it because these guys need to be taught a lesson. They've sold shares that they don't have. They've taken trillions of dollars from retail investors. It's time to stop. It's time for someone to stand up for what's right. But unfortunately, it's not going to be Gary Gensler.
Yeah, I forgot to mention this. We have a new feature. We have a weekly feature starting this week. The weekly feature is the Scumball Regulator of the Week. And this week's winner is Gary Gensler. Congratulations, Gary.
He's likely going to be this. He's last week's winner. He's likely going to be this week's winner too. In front of the Senate or the Financial Services Committee.
He's getting winner.
He's tonight's winner.
He's tonight's winner. And
we need to have an award for him.
No, the award, getting the award is enough, really.
So
and
recognizing him.
Yes, he's got to be very proud, really.
Scumbag regulator of the week.
Yes. Yeah. Every week we'll pick a different regulator that fits. And, by the way,
it's the SBRW award. SBRW award.
Okay. SPRW. If anybody at some point in time during the week thinks of a regulator they'd like to nominate, in the comments during the week to the video, they can post that. We're going to look at the comments during the week. And if you think of somebody you want to nominate that's the biggest scumbag that week, go for it.
I think we should tweet out an invitation for Gary Gensler to come on and accept his award this week.
I will. I will. I'll offer him because it's quite an honor.
I think so too.
I was going to say is that secondarily to what you were saying, he objected to disclosing whether there was an ongoing investigation. And as I pointed out in their response, so this is the SEC's response to FOIA requests, they assert the exception that says there's an ongoing investigation. So I think in legal terms, he's full of shit.
Yeah.
Because they've already used that as a defense. So how could you use it as defense and then say, I can't disclose it? I think the cat's out of the bag, GGDH.
Well, it's ridiculous. I mean, think about how number one, how stupid it sounds. We know there's a fraud investigation. We knew there was a fraud investigation back on December 5th because Sam Drady indicated that it had hit the fraud desk and he had pulled the blue sheets for MMT and MMTLP. Well, if you go back to the summary of what the electronic blue sheets are for when the regulation was promulgated, it says right in there to examine market manipulation. So if you're pulling the blue sheets, you're examining market manipulation. If you're head of the fraud unit, you're investigating fraud. And so this notion that there's no investigation going on, or we can't confirm or deny that there's an investigation is stupid.
It's also the argument. I don't even know if I've ever seen it made by FINRA or the SEC, but it's implied, I think. The argument that they can't get a share count to us in 5 seconds. Yeah. They need some 30-day process to figure it out. I honestly think that's literally a 5-minute job.
Oh, sure.
Literally a 5-minute job.
Well, that was what the response was back to Mark's, FINRA's response brief was that it's overly burdensome to produce the documentation. Now we know that's bullshit because they pulled it on the 5th. So they already have it. There's no, what kind of a burden is it? So I'm sure they pulled it again on the 8th after they halted. And if they didn't, they're incompetent. So the whole argument's just BS.
And of course, to the extent that they're concerned about, confidentiality, whatever, nobody ever asked for names, account numbers, whatever. And if they wanted to, and I asked for this when my federal litigation was ongoing, I asked for that the documents or like a declaration or penalty of perjury be submitted to the judge. Let the judge verify the number. Let them make a declaration or penalty of perjury. Let's put them at risk of going to prison, and let's see how accurate the numbers are thereafter. And that wouldn't necessitate any type of disclosure beyond, to anybody. So, but it would disclose the number, and ultimately. So I never believed. I think it's a BS argument. I think it's purely a way of protecting. And I was going to say this, protecting the bigger issue. And one of the things I was going to bring up was. I think the SEC, it's funny that you brought this up. The SEC is walking a fine line. They're trying to stay alive. At the same time, they're trying to impede their buddies as little as possible. So to the extent we think, and this is where that question went, I guess. We somehow worked it back. I was asking you how could they not be making these decisions, or how does the SEC decide what to do? What's motivating them to not act or act? I was always wondering if you thought there was any bribery going on. And I know you don't have specific. Okay, let me put this in a box. I know you don't have specific information about some guy paying off some guy. And I know you might consider bribery, or I might consider bribery at some point in time. You might offer a job to a person and to their relative, or a vacation, or something like that. And I know you don't know, Or maybe you do and you're just holding back on me. So tell it now. Disclose it now. No. So do you think any of that type, do you think any of that type of conduct is going on?
No, I don't. Not when it comes to the citations and the fines and the settlement. I don't. And I don't for a couple of reasons. Number one, it's too obvious. Number two, I was able to be privy to, settlement discussions that we had for that we were having with OSHA. And, if the conversation is anything like that, the regulator came in and was like, all right, here's the violations, here's the suggested fine, what are you willing to pay? Where can we land in the middle so that we can button this thing up today and everybody walks away happy? I truly think that's how those conversations go down. Now, does everybody get in a room? No, probably not. There's probably just email exchanges between the attorneys. They come up with a number, everybody's happy and walks away. I don't think there's any bribery in the paying of fines. I don't really, and I'm not a conspiracy guy. I don't know if there's actually bribery in terms of actual kickbacks and, hey, here's $20,000, look the other way. But I do think there's an unspoken, arm's length between the hedge funds and regulators, where the regulators basically say, look, do what you're going to do. Don't fuck this up too bad and make us look bad. Otherwise, we will have to expose you at some point. And if you don't do that, we'll look the other way. And when we see egregious violations of, we asked for data and you sent us the wrong data, we're going to nail you. But we're not going to come after you to examine all your trades, to see what you're doing, to see if you're selling counterfeit shares on a daily basis. I mean, Ham says that all the time. The SEC knows what's going on with GTII and Finger. For fuck's sake, they park a fucking truck in front of the SEC building every day. The one day it had the middle finger sticking up. How can they not know? If you're an employee of the SEC looking out those windows, you see that truck when it's out there. You see it when you walk in the building. You see it when you walk out of the building, which, by the way, one day I'm going to drive that truck.
I saw that. Just drive it well. Drive it well.
Put that out there. So this notion that they don't know is just ridiculous.
All right. So I'm going to also I really wouldn't say I'm a conspiracy guy. I'm not. But I believe there are some conspiracies. So if that makes me a conspiracy guy, whatever. I just think most are not. So, and I think people jump to that conclusion. So would I believe there was bribery? No, but I'll give you like some exceptions that kind of puts it up in the air to me. One, what happened? The fact that we're talking about a huge amount of money. And if that's the case, would it shock me if somebody got paid off or got some compensation or got something? No, it would not shock me at all. And in my work as an attorney, so I work in California, LA Superior Courthouse, the one that I practice the most, happens to be the busiest courthouse in the world, as it turns out. Just because we're so freaking litigious out here, just happens we are. And so I've been involved in a lot of cases over 35 plus years. And even though I had gripes about a lot of judges and still do, most of the time I figured they were just bad judges and it was nothing, whatever. But there were a handful of times where things occurred in cases where if you had to ask me, I would say somebody intervened in some fashion. Wasn't a lot of cases, literally a handful, but that's why they kind of stood out. Because it's like anything else. If you do something long enough, you kind of have an intuitive nature about it because it's your thing and you kind of know all the details. And when things smell off, you kind of know it. And
sure,
there were like a handful of those kind of cases. So that made me believe maybe. Then one time, a friend of mine who was an attorney told me that even though he didn't believe it, his client said that if, I don't remember the name of these people, by the way, but I remember the story. His client said something to the effect that they could reach the judge and pay off the judge. This was in a civil case, by the way, also. It wasn't a criminal matter. Right. He said he didn't know and the case resolved, so it never went anywhere. But the client presented it to him like they really could exercise influence. So
Right.
that kind of also impacted me a little bit. And then one time I had a client that was in the cell phone business in LA, and he was a small guy relatively, and there were some big players. It's not AT&T, but like that, who would have preferred not he be in business. And one time there was a raid of his store midday, like at noon, and like 15 sheriff's cars block up on a very busy street in front of his business. And they have a search warrant. They go forward and they don't find anything, by the way, but they made the presence known. And
Right.
during this proceeding, my client had and I wasn't there, so I don't know if this is true, but my client had an interaction with I guess he would have been the head, like a captain. So there's a bunch of sheriffs that come out. There's some guy who's in charge. So that guy who's in charge pulls my client aside. They go outside, and my client, by the way, I knew him, and he had no reason to not tell me what was going on.
Right.
The guy said, "I have information," and I don't know this is true. This is like 150 years ago. I don't know if it's true. I have information from the other side about this dispute, and it would really hurt the other side because it would show they were conspiring to put you out of business.
Right.
So if you take $50,000 in small bills and take it to this PO box and drop it off, I'll give you the information. Which I thought was, and again, my client had no reason to lie about it.
Right.
He didn't do it. I don't remember if he reported the sheriff. The case kind of went on. But that's a handful of times where I actually believed that there was some kind of bribery that might have been going on. So
Right.
do I know in the current case where it's going on? I don't know. I do not know. But I'm not going to say 100% that it's not. And I think even if it's not direct, it's indirect, like we said, that maybe it's a future employment situation or something else. That's kind of how I see it. And it's troubling. That's kind of why people want a wall between regulators and the capital markets, so
Right.
one doesn't influence the other. And I think that's being perfectly reasonable. Boy, we've been talking about that a long time. So I'm going to move it along. Unless you have something else you want to say about the topic?
No. Well, it's an interesting conversation, and it's just something we could sit here and talk about all night. So
Yeah. And listen, getting back, I guess to close the point out, SEC has to walk a fine line. They're covering for certain people. They're trying to keep their jobs. I think they're trying to let some retail win, not a lot, some, so they can use that as propaganda to support their continued position in the government or working for the government. So they probably realize that they have to resolve some amount of disputes each year, but they're going to resolve the fewest. And I believe, like MMTLP, it's kind of like the squeaky wheel gets the grease. So the more kind of a hubbub you can make, probably the more response you can get. That seems to be certainly the case with MMTLP in terms of the congressional response. Obviously, the amount of I was seeing, like, on stock twits, the amount of coverage like finger motion was getting is a lot. So there is a lot of news. So to some degree, I think the stocks that get the most publicity and make the biggest stink will get the most respect and action from the SEC. And I would encourage everybody, not just MMTLP, because I encourage MMTLP, but GTI and Finger, which I'm both also in. Everybody should be bitching and making this a problem and making it noted. Because again, I think only a few are going to get treated each year.
Right. Well, the situations are a little different, and Ham and company are doing that. I mean, parking that truck. Well, every time that truck is there, William goes live and is talking about it. And my understanding, William's talking to people as they're coming in and out of the building. So they are in an essence. Now MMTLP is a little different because of the circumstances, obviously, and the response obviously was 100 times different because the congressional pressure over the last 10 months. I mean, there's Senator Crapo point blank, asking questions of Gary Gensler on MMTLP. I'm 50-50 right now whether or not someone on the Financial Services Committee this week is going to donate all of their time to ask him the same level of questions that Senator Crapo goes. So it's certainly going to be interesting to see if it's brought up during that hearing as well.
I hope so. Yeah.
I'm just going to say, you and I have talked. I mean, we've been talking about this for weeks now. So.
Yeah, and with others, we kind of helped in the construction of questions that may be used in these proceedings. And I know I prepared some kind of, pseudo cross-examination for Gary Gensler for having fun, but kind of like throwing it out if anybody wants to use it. So it will be interesting. And again, I will represent Representative Crapo in any name change proceedings he wants to undertake. It's out there, just so he knows. Just so there's no mistakes with that name. I have problems with that name myself.
I did too a couple times. I had to mentally pause for a second to make sure I said it right.
Yeah, I know. It's you really have to be thoughtful about that. So
right.
So let's move on a little to finger motion. So finger motion is so GTII was what we mentioned. That was Alpine connected. Finger motion is that other security that a lot of people are either in or following or whatever. We certainly are not recommending it. We recommend nothing because we know nothing, honestly. But it's currently we're aware of it. There's a lot of, we're watching it carefully. I think we both own it, right? We both own it, and we're obviously hoping it does well. So what's interesting about finger motion is, so that's a heavily shorted stock, but it's an ongoing business. It's a Malaysian company that has done business in China, has revenue, and apparently is a good business. But on top of that, has a bunch of shorts, naked shorts, counterfeits. By the way, I refer in my arbitration materials, first thing I talk about is counterfeits. I don't refer to naked shorts because they are counterfeits. So, but apparently, finger motion has a bunch of counterfeits too. There was a new underwriter, lender, somebody who has just come in or recently come in, who will be apparently facilitating the purchase of shares of stock in large numbers. And historically speaking, the name of the company is Univest. Historically speaking, a lot of companies that have been connected to Univest, their stock prices have done very well. So people are anticipating that. And there's an S3, which is obviously an SEC form that is pretty much a rudimentary form. So it usually doesn't get a lot of scrutiny. That was filed on the 21st, I believe, of September. And generally, they are approved within a general 2-week period of time, outside 27 days, I think. But I think comments have to be done in 10 days. I think that's what I recall. Or they should be done within 10 days. I don't remember. But that
I don't know the specifics. I just know that it needs to be approved.
Right. So and there's a system, there's some guy named Edgar, I guess, who sits in his room and he gets all the documents and he puts it in his home computer. It's called the Edgar system. And so everybody who's following finger motion or GTII probably about every 15 minutes goes to the Edgar site to see if that stupid S3 has fallen. And the reason why they are waiting, because people think that when an S3 is approved, that will generate a bunch of interest in the security, greater selling of the security, and then that Univest will come in and will be a buyer. So that's what everybody's waiting for. And it's interesting to hear the psychology people, because it's hard to wait. And so to me, and JR and I have talked about this, to me, it feels very much like the feeling I had December 7th, 2022. if people remember that feeling. I remember with the MMTLP gang and kind of with these amazing expectations. And I remember the positive anticipation that I was expecting, which changed obviously quickly. Not saying this is the same setup, but that's the feeling that I have.
So I do not share that feeling. That's not the feeling I had on December 7th, because I had watched the stock get decimated that day. I think it's more akin to the run up to kind of the effective date of the last S1, which was November 18th. So that period between the last
You're
S1,
referring to MMTLP.
referring to MMTLP, that period between the I think it was the third or fourth S1 and then the final effective S1 on November 18th. It's eerily similar to kind of what the people in MMTLP were all anticipating and expecting. I did not have that feeling on December 7th. Trust me.
I was talking about early in the morning.
Yeah.
But what's interesting to me is how people, and I'm not talking about psychology, because that's, to me, it's interesting. It's because, we're going through the same experience, is people create these rules that don't exist. They create kind of formats that don't exist. I'll just give you an example. So we just said that there really is no time frame for when the S3 has to be approved. But it has to be done within 27 days. But if it happens on the 26th day, that still counts. But generally, it happens in less than 2 weeks. So people then surmise if it doesn't happen within 2 weeks, that it's not going to happen. And they actually believe that. They really believe that. And either they'll get depressed, or they'll sell their stock, or they'll do something else and be influenced by that, which is just something they created themselves.
Right.
Really. It's just, and on top of that, which this part makes it tough, there is obviously a group of shills that run throughout. Yeah. It's not I don't think it's a great number, but it doesn't have to be a great number, but enough to create some doubt in the marketplace. And you see it, you see the references, and people can definitely be influenced by those. Sure. And that's why they're doing it.
Well,
there's no other reason.
The thing that I find interesting about what the path that you're going down now is, and I'm acutely aware of this because I watch it and I find it fascinating. But take a step back, go back 3, 4, 5 weeks ago. You had, you had these 3 big communities. You had the finger community and the GTII community, which both of them are kind of intermingled. And then you had the MMTLP community. Now, there are several people in the MMTLP community that are holders of both GTII and finger. Go ahead. Sorry.
Do you see it on your screen, by the way?
Yes, I see it. Okay. It's on there. Okay. And so you have these 3 intermingled groups. But one of the things I noticed several weeks ago was you had your own distinct shills. You had shills in the GTII community, you had shills in the finger community, and you had shills in the MMTLP community. But what I've seen over the last 3 to 4 weeks is some of these shills are conglomerating into the finger community. And I mean, I'm sure you all can see it. I just find that interesting that, you're now starting to see crossover where before you didn't see any kind of crossover. And it's almost like one of these communities needs a little support from these shills or paid disruptors or whatever you want to call them. I tend to only focus on that when I'm reading and seeing kind of this back and forth. So I find that interesting.
So I expect, I expect the S3 to be approved, and I expect that if it's not, if they asked for some clarification,
right,
then we'd find out about that. That would come out,
right.
And shortly thereafter, it would be approved. So I don't see how it would not be approved, especially with Univest they've done a bunch of deals. This doesn't seem to be out of the ordinary. So I expect it to be approved, but whether it's going to be approved tomorrow or on the 27th day, I don't know. And
Right.
even though personally, I'll be honest, even though personally, I'd much rather be tomorrow morning we wake up and it's crazy land, right? I would
That's
like
my life
that.
every morning, Richard.
Yeah, well, it is like every morning, but crazy land in a good way. That they filed their the S3 has been approved, and we get a bunch of buying pre-market, and boom, not legal or financial advice, of course, but it's not going to make me think it's not going to happen until we get past the 27th day. So,
I don't know. I mean, I have a very good patience, so I'm just kind of sitting back and watching. I mean, you and I have talked about this. I mean, my I don't know why, and I could be totally off base on this, but I vaguely remember, again, going back to November and October of last year, I thought I saw a tweet by someone that basically said, typically the SEC posts those things early in the morning. So, if it's not there by 8:30, 9 o'clock, if it's not there by 8:30, 9 o'clock, you might as well just wait until the next day because it's not going to post later on.
yeah,
Again, could be totally off base, but I vaguely remember seeing something like that.
yeah, I would say generally they don't want to influence the marketplace, so they'll either do it before or after, but probably not during. So it'll either happen either when we wake up, unless we wake up really early, like I do on the West Coast. It'll be up.
Oh, are you up early on the West? I didn't know that. I always wait until like noon to call you. Is that why you're always in your car then?
I got two dogs. So Agatha, my little dog being almost 70 pounds, by the way, that puppy is almost 70 pounds.
That's not a little dog, dude.
No, that is not. She likes to wake up around 5:30. So that's me. I'm up. So I'm always up.
Wait, 5:30. That's 8:30 my time.
Yes.
Yeah. Oh, all right. I didn't think. All right. Good. Now I know. I can call you at 8:30 and you'll be awake.
Yeah, I still may ignore you, but but
Jesus, not kangaroo with deep pockets.
That's pretty good. I like that one.
It is a cool feature. I like that William does that because then well, the thing with William is when he does that, you can see how far behind he is in the conversation.
Yes. Because at times he gets a lot more, I think, comment flow.
Well, yeah, I mean,
yeah. I appreciate, by the way, everybody who comments and takes the time to comment. By the way,
and I will tell you, I am glancing at the comments throughout the entire conversation because unfortunately Richard can't see them.
Yeah, I could see him if I look this way, but also William does like a 9-hour marathon, so he's at like 1,500 million comments to go through.
I looked at the one day, it's like 6 hours. I'm like, what the hell?
I know. I saw one live stream that William was doing when he was asking Lucky to read the comments, and I was taken aback, but whatever. Okay, anyway, but it is nice to do it. Anybody, so if anybody posts comments that we find interesting, although I have to put everybody on notice right now, it's a complete algorithm. We have no choice over which comments are posted, so don't blame us. Don't blame us.
Can I post one? I can't post one. I need some kind of user control. You need to give me some kind of authorization here.
There is some way. I'll have to I saw it. I was actually looking before the live stream. There is some way, and I'll make sure it's in play before our next one. Right. Finger motion, just the psychology and people waiting and the anxiety and the S3. And again, it's interesting how people create their own facts. They just kind of do that and they'll act upon it. And the people that are on the opposite side of the transaction use that to their advantage. So anyway, I find finger motion really interesting. And of course, we will see where it goes.
Yeah, it's definitely going to be interesting to watch. So
before I go on, to be honest, I really love whiteboards. They're actually remarkable. Anyway,
I'm going to say it again. Someone made a comment on Williams' live stream. I think it was today that the jokes are just bad, Richard. They're just bad. I laugh at them, but it's complimentary.
You know what? Because I have a poker group I play with. So, if you're around me enough, what happens is you'll start making the same jokes I make. That's what happens. And you'll,
I don't know, man. For two really complete strangers last year at this time, we're around each other an awful lot.
That's true. That's true. That's true. I accept any response as a positive response, even if it's a negative response. So I appreciate it. Thank you very much. So anyway, finger motion tomorrow. It'd be interesting to see what happens. Everybody's excited. Again, I'm sure everybody will check Edgar overnight. And for anybody else, if you want to find filings as to any publicly traded company, you go on that site. So if you Google Edgar system, it'll come up. It'll kind of have a menu. You go in, it'll ask you for like the name of a company. You'll write the name of the ticker. You write, like if I was doing finger motion, if I put in FING, it'll bring up finger motion. I press that, and then a whole series of filings come up. So if you want to keep track of that, that's where it will be. And we believe what will happen is, as to the S3, there'll be some kind of notification that it's effective or something along those lines. That'll be what shows up. And as of now, it has not. Oh.
Put that one. You have to put that one up. Oh goodness! See, that's
great. That's great. Great. Wonderful. I also, by the way, I think you could change your name to Muddy also, just so we keep it straight. Okay. So we did finger motion, and the excitement in GTII is obviously the twin. People think they're kind of twin because there's common ownership, a lot of shareholders, and people believe that if one goes, the other will go. And
oh my God, how
funny.
Oh crap.
Pretty good. See, folks, pretty good.
Listen. We talk serious, but at the end of the day, this is the best.
All right. So we're going to move on to because we're going to have to finish all these. By the way, on finger motion, what was interesting last week was brokers such as Fidelity actually are chasing shares. So they're looking for shares. So it suggests there are short shares. And
go ahead.
No, finish. Go ahead. Help yourself.
No, I was just going to say that, you're seeing a lot of that, and I'm paying attention to it. I'm paying attention to it because my position in GTII is significantly bigger than my position in finger. And so I've been paying attention to those posts where people are saying, hey, I got a call from X, Y, and Z broker. I think Fidelity was the latest one, asking to loan out their shares. Now, I've not gotten a call, but like I said, I'm paying attention to it because my holding in GTII is significantly larger than finger, and I am on a cash account. So in theory, they could pick up the phone and call me and say, hey, we want to borrow your shares. So, and I will certainly be first to post if and when that does happen. It's past midnight here, and I'm listening to you guys talk about finger motion. Oh, is that who's? I'm sorry, I'm terrible. I can't. There's no way I can pronounce that name.
That would suggest a different time zone, I guess.
Yeah. Thank
you. Well, thank you, or I apologize, or you need medical assistance. I don't know which one.
Probably.
Probably all three. So it's again, everybody's interested and everybody's following, and it'll be interesting. It'll also be interesting to see what impact one going has on the other short share, short stickers. Because people think finger motion GTII are connected. Will that put pressure on MMTLP, other tickers? It'll be interesting because I don't think there's been a time where there's been this much communication amongst retail where these events happened. So it'll be interesting to see.
No, I would 100% agree with that. For as much division as they're in, as there is sometimes in the MMTLP community. At the end of the day, people are still working together behind the scenes. They're working together, on Twitter, and it's no different with these communities. I mean, look at us. We started out in MMTLP and we got dragged into GTII, and now we're dragged into Finger, and I like that, because, and we talk about this all the time. It's education. We're here to help. We're here to talk and help people understand stuff.
Yeah. Before we go on to we're going to go on to the Uptick rule, which I think is going to be interesting. Maybe. I just wanted to point out that story I did about Prehistoric Salami was absolute nonsense. I was just curious if anybody was going to respond, but just so everybody's clear, public disclosure, nonsense, not true, zero true.
Yeah, I was wondering that myself because never mind.
Yeah, now he says, okay. So let's talk about
I was questioning the accuracy of cured meats being started in Egypt and lunch meat stands being set up, to feed the people, because my understanding is that's not what they did, and again, I'm not a historian, but
yeah, as far as I know, there were no delis in the Egyptian desert, as far as I recall.
A certain deli is, well, yeah, never mind.
Yeah, there might be a New Delhi in India, but no place else. So, Uptick rule. Tell me about the Uptick rule.
Woo! Well, it's no longer in effect, if my understanding is correct. So the Uptick rule, based on my limited knowledge, which you educated me on last week because I had it confused with the short sale rule, or the SSR, short sale rule, SSR. So the Uptick rule is
it is actually related to I mean, I agree, it is kind of connected.
Well, there's two. There was the Uptick, and then there was the short sale rule. The short sale rule is basically if the stock drops 10%, you're not allowed to short it unless it's going back up. And so what. And I remember this from the GME AMC days. There was always a lot of hoopla around, well, they shorted it down 10%, SSR is in effect, so we should see an increase the next day, and we never did. Whether that was due to manipulation or due to people getting out, I don't know. But now it's the same thing. Now what we're seeing sometimes with GTII and Finger is it's not dropping the 10% and flipping the switch for SSR for the next day. It gets to that 8.5%, 9%, and then that's where it holds. The Uptick rule is the inverse of that. So if correct me if I'm wrong, but if it was shorted down, in order to short it the next day, it had to increase by $1 or they weren't able to short it. So there had to be an uptick in order for them to be able to have short sales on the ticker the next day.
I think it was even actually the next transaction. So you couldn't have basically what occurs now, and I think you hear people talking about it. If they want to sell the crap out of something, they just press the buy button, buy, and they can control the flow of the transactions, buy, sell. The original Uptick rule, apparently, I was around, but I wasn't paying attention. In 1934, I think I was 42 at the time, and when they
is that it?
Put out the uptick rule, and probably correlated with the depression and the stock market crash, and in essence it put like a momentum block. So if somebody wanted to short something, they could, but they had to wait for the price to go up before they could go back down.
Right.
So it impedes the momentum of the downside in particular. In 2007, I think the timing is ironic. In 2007, the Uptick rule was removed entirely. And I think 2008, there might have been a bad event that happened in the economy of the United States.
I'm not aware of one.
Might be correlated. In 2010, they passed a new rule. I think it's rule like 211 or something like that, which is if it's in California, I think that's robbery, by the way. The penal code 211 or something like that. But it basically said that if you were, what kind of JR was saying, first 10%, no problem. Then after that, we got to wait for a uptick before you can continue to short it. But if there's no upticks, as long as the sale price is above the bid price, the highest bid price, you can go ahead and still do the transaction.
Right.
And it still relies upon somebody to be governing and watching this nonsense. So you know how many times I don't know why I think I've watched so many tickers where I see a movement like 50% and nothing happens. Where is this rule about the 10%? How has that come in to stop the the massive swings? I think it's nonsense, honestly.
Yeah, I do too. I mean,
yeah, but basically you can't stop the momentum, and somebody's got to be watching, and certainly the first 10% you're gone, and thereafter you could still do it. And ultimately the problem you have beyond all this is, and I think William and Ham have both discussed this, is you can still create synthetic shorts. You can buy put contracts and sell calls, and you in essence create a fake short share. So to get rid of this, you'd have to regulate that. And I don't know how you do it, but you basically say you can't do it. You could do one or you could do the other. And maybe you could do both, but you can't have some sequence. And I'm sure, by the way, it could be done. You could figure out a computer program could be generated so that it sniffs out that kind of misconduct. If you recall, I remember early on when we were looking at FINRA and the SEC, one of the things they bragged about was their software and their ability to detect fraud and whatever. Yeah. So if that's the case, unless they're BSing more than we think they're BSing, they certainly could track that stuff, I think.
Well, they're detecting fraud. They're just not detecting the right fraud. That's the difference. You know, this, right. Well, you mismarked your blue sheets. You mismarked, a long as a short or short as a long or whatever. They're just, it's done to keep the status quo going. I mean, that's it. They're not looking at the real fraud that's going on a day-to-day basis. I mean,
and the assertion. And I think the assertion always, by the way, I think this is always the answer. It brings liquidity into the market. All these like tools, there's plenty of liquidity in the market. Maybe there was a time where there was not, but now there is.
And it goes back to what Ham said this very early on about Alpine. He hasn't talked about it in a while, but the reason FINRA went after Alpine wasn't because they were ripping off their customers. That was a byproduct of the investigation they were doing. It's because they weren't paying their proper fees to DTCC. And, these agencies, these SROs, these private corporations, they want their money. And that was initially why they went after them. And then I'm guessing that once they went after them for that and started really taking a closer look at their books, they found all these other violations, which was the result of the first enforcement action. But if you remember, if you look back over that first enforcement action and then the second one, they weren't paying the right fee to DTCC.
Right. And just a quick comment on that. So Virtu, I like this one always because Virtu is my guy. The guy who owns the Florida Panthers, who lost the Stanley Cup Finals, who criticized one of my jokes in one of my videos.
You're special.
So I'm special. Anytime I see that name, I feel a warm spot in my heart. And I'm so glad he lost the Stanley Cup. So thank you, Dougie. Dougie is his name. Dougie. Yeah. So, it's interesting though. They obviously could go back to the uptick rule, right? They could do that. They could modify it as opposed to 10%, make it 2%, make it 5%. Somebody pay attention. Have a program that catches it, something along the lines. But obviously, in my opinion, by the way, I ran this by a broker friend of mine, and we were talking about getting rid of shorting. And he said, you can't get rid of shorting unless you get rid of the synthetic shares. The synthetic shares being the puts and the calls. And I basically said, I don't want to get rid of them. I just want to get rid of the sequencing. And I definitely think it's possible to do. So we really need that to be addressed to stop the shorting, because otherwise you can kind of work around it and it's still BS. And the fact that they got rid of it in 2007, we had a crash in 2008. I mean, is that a surprise? Yeah. I mean, I don't think so. And the fact they had to kind of like try to make nice by having like some BS rule in 2010. No, that's kind of, and that's not Gensler, by the way. That's some other, probably would have been a winner of the weekly award, weekly regulator of the bad regulator of the week if he was around, he or she was around. But that was, that does nothing. That creates the playing field we're in today. And it's probably worse. I think it's worse today than it probably has ever been because of the ability to do computerized trading, the ability to kind of trade, literally billions of shares, whatever. So we think the Uptick rule should come into play. However, if those donkeys, I'm referring to all those donkeys out there, if those donkeys aren't willing to do that, then how about let's readjust the settlement rule so that the short side has to comply with the same as the long side? Is there any justification? Because maybe there is, but are you aware of any justification why the shorts should not have to comply with the same standards as the longs? And if you don't comply, if you don't deliver your money in 2 days, I'm buying you in. That's it.
No, there's no reason other than, what goes back to the very first part of the conversation we had. Is there some type of kickback going on? I mean, these are the people that are they're the ones that are pressuring the SEC to make certain rules or make certain changes to rules or not implement certain rules. So they're the ones that have the dollars. And, they might not be paying them out of their pocket, but hey, this is what we need. This is what we want. And oh, by the way, there's going to be a $350,000 a year job waiting for you when your 2-year stint is up at, the SEC. So this is what we want you to push right now. This notion that they're the ones that are making the rules is absolutely ludicrous. And Dave Lauer talked about this. I remember, a year ago reading some of his posts on some of this stuff. And the perfect example is the Madoff rule. We have this rule that allows bona fide market makers to sell shares short that they don't have or can't locate. So basically a counterfeit share if they are a bona fide market maker. But the nickname of that rule is called the Madoff rule. And as we know, Bernie Madoff died in prison for defrauding billions of dollars out of his clients. So the fact that we have these types of rules in place that are made by, at the end of the day, criminals is ridiculous. And so the short answer is no, there's no reason for it.
Do you know that actually that's not his real last name? It was
Madoff
changed. The former, his original name was different, but he made off with so much money he had it legally changed. Excuse me, and I apologize for laughing at my own. I apologize. Sometimes I'm the only one though, so you got to give me that one. All right. So obviously there has to be adjustments. Without the adjustments in the Uptick rule or the settlement period, it's going to be tough to combat shorts to the extent we'd like to combat. And that goes along with the next topic we were going to talk about, share lending. We've talked about share lending, in terms of the brokers make most of their money from the share lending. So sure. They're covering a short position. Literally, they're lending out shares. They may be lending out the same share 100, I'm making up numbers, but could they lend out the same share 10 times? Sure. Why not? Why wouldn't they? Because if they're making the most money out of that, why not? If nobody's going to enforce that, what would encourage, I'm going to use, like, just for the sake of discussion, let's use Fidelity as a topic. So if Fidelity is making billions of dollars on lending out counterfeit shares of stock and nobody is coming after them, why would they stop?
Well, yeah, why would they? But it begs the question, is there an argument to be made there that they're violating their fiduciary responsibility by enrolling and allowing people and encouraging people to enroll in a share lending program? I mean, the share lending program, the whole premise of the share lending program is to take your share, loan it out to a short seller so that person can go out and short sell it in the hopes that it drives the market down.
Yeah.
How is that being a fiduciary to your clients?
Well, let's say you weren't. let's say, because they argue sometimes they're basically a sales agent. They're not an advisor. So they don't, as such, they don't have a fiduciary obligation. But when I was looking at this, and I've never heard this before, by the way, so I was kind of surprised. So so what happens when let's say your Fidelity, I'm just going to use for example, Fidelity calls you up. I want to buy your finger motion shares. Okay, what are you going to pay me? So if they made $1, maybe they pay you 5 cents, because it's certainly going to be a small fraction of the amount of money they're paying you. Then secondarily, if you own that stock, now you have sold a short position against your position. Right. So you are working against your own position. Exactly. So even if you made your little 5 cents, you're probably going to pay a lot more than that. 3, when you let your shares be loaned out, you lose voting rights. So you no longer can vote your shares. So, and again, I don't know if any of this is disclosed anywhere when you decide I agreed to lend my shares out. So do I think, and because I'm going to get to the fourth part, which is going to floor a lot of people, I think. When Fidelity calls up somebody and says, I want to take your finger motion shares, I'll give you a nickel a share. Are they telling them this? I mean, are they disclosing that you're going to lose your voting rights? So that's okay. If that's okay with you, fine. There may be, a counterparty risk because there could be a default. The collateral might go down in value, so there might be risk like that. Are they telling them any of that? Is any of that disclosed? Is any of that disclosed in the customer agreements? Because I haven't seen it, to be honest. But
the last, it's not in terms of service, because I read over Fidelity's terms of service agreement. It's not in there.
Yeah. So now we get to the fourth point, which I was floored by. When you lend that share out, you lose SIPC coverage. So there's insurance coverage for the securities. When I think it's up to $500,000 per account or per account holder. As soon as you lend out those shares, that is no longer covered. So you have an increased risk.
That's interesting. I didn't know that.
Yeah, and that is not disclosed as far as I know. So it's interesting. You lose the SIPC coverage. You retain, to the extent there's collateral, that is covered still. But the likelihood is, if there's a problem, that collateral is going to be worth less because it's probably the stock, and you're not going to be able to collect. The amount of the collateral is going to be less. But the fact that you lose insurance protection, not to say that at some point in time, if Fidelity, I'm just using Fidelity as an example. If Fidelity went out of business tomorrow, do I expect that somebody would come in and take care of their liabilities? Yes.
Yeah.
But is it guaranteed? No. And should they disclose that to their customers before they stick them in a share lending program? Absolutely. And I think that is at least negligent, at least. Yeah. But I think it's done intentionally. That like everything else, it's information that's concealed, because if they came to you, JR, and they said, I'm going to lend you these shares, let me tell you the risks. At the end of the conversation, a lot of people would say no, and their bottom line pocketbook would be influenced. And as I kind of mentioned, since I have I'm dealing with Fidelity, they're a private company. We have no access to their financial information.
Right.
Their financials aren't public. We don't know what they do. And the head, so it's run by the Johnson family. It's located in Boston. I think JR went to their headquarters. It's located in Boston. I think JR was trying to storm the headquarters, but they repelled him.
No, let's stop a second.
All right.
I was at Fidelity's headquarters on multiple occasions when I worked at the airline, and that's the only reason I was there. We did quarterly meetings, and every 6 months we'd go up and have our quarterly meeting. Then the following time they'd come to us, then we'd go to them. So yeah, I spent a lot of time in Boston at Fidelity's headquarters, and that's the only reason I was there, Richard. You've got to stop making jokes like that.
Yeah, I agree. It was not a truthful joke. I agree with that, and I will represent. I agree to represent Jr. So, um, yeah. So anyway, so the clan, I call them a clan because it's a family that owns Fidelity. It's the Johnson family, and Abigail Johnson basically runs the business for the family. And I was looking up her net worth. I wasn't looking it up. Bloomberg published it, and they said her net worth was approximately $34 billion,
Oh, it's
which
ridiculous.
which in my mind makes her, she's got to be one of the wealthiest women in the world, right? I mean, she's got to be in the top 10, top 5 wealthiest women in the world, I think, at that number. She's substantially more, I think, than the Walmart the Walmart women. I think she's literally amongst the wealthiest people, and we have no access to any of their financial information. And
Nope.
we know that they're chasing finger motion shares. We know they were probably chasing MMTLP shares, and we know they're probably chasing all kinds of shares. They're making tons of money on this.
They are.
They're not doing the disclosures they need to do. One thing, if I was going to say, if I went to Congress and I said, what kind of rule can we put into place? Here we go. Make it a requirement to disclose when you're doing share lending what the risks are, and make somebody sign off. Give them a day to contemplate it. You could set it up so people would have adequate time, especially if the language was not very easy to understand, but give them adequate time to make a decision. And again, if you disclose the fact that you were going to get peanuts, but you were going to work against your own interest and create greater risk in your own securities, why would you do that?
Yeah. Yeah, I agree. I agree. They should be required to disclose it. I'd go a step further and say that, there needs to be some type of rule or regulation that if you're loaning shares, if you're borrowing shares out of an individual's account, that individual should be entitled to 50% of the profit. That would change the game, because in reality, you're making pennies on the dollar when they loan your shares out. They're making oodles of money and you are making nothing.
Yeah, and I believe, again, my solution would be to get rid of share lending, because if you got rid of share lending, there would be no shorting.
Yeah.
And we're done. Or make it super restrictive, but not like Fidelity shouldn't be operating as a bank. Really, should not.
Oh,
and,
no.
and if they are, then they should disclose that too. And again, and I was going to say, and again, they're a private company, so we don't have access to that. And obviously, they have billions and billions of dollars they're manipulating, or may be manipulating, or have control over. Anyway, go for it. I'm sorry.
No, I was just going to say, I know this for a fact because I worked in this industry for 20 plus years. I'll guarantee you that trustees and fiduciaries of the pension plans have no idea what's going on.
Yeah.
No
yeah.
idea.
So anyway, yeah. So we think the share lending is that is a disgrace, and that's a hidden element that really impacts people's securities, and permits shorting. And again, right. I don't really hear it discussed. I didn't hear this, especially about the insurance issue, the SIPC. I never heard that discussed. And again, I think it absolutely should be disclosed. So last but not least, we get to MMTLP to finish off. So Woo-hoo! Yeah, so we obviously are both in MMTLP. We decided is every week I bring you up to speed on the Fidelity arbitration. If there's any other matters that are ongoing, I know Mark, for example, is working on stuff. I think Alan's still involved. I think Hands of Steel is still involved. I know Rose is on appeal. That's my understanding. So there's still stuff that's ongoing. My main focus at this point in time is my Fidelity arbitration, and to see what we can garner out of that arbitration. I have more than a dozen claims, and I'm seeking damages information, declarations, and everything else. And I've asked for discovery in the past. I've asked for depositions of various people. This past week, I asked for the deposition of Mr. Gensler. I've asked for the share lending documents of Fidelity, of the share lending documents related to MMTLP or NextBridge. I've asked for the financial statements of Fidelity, all their balance sheets, all their transactional information. This is on top of prior documents that I asked, and there's about another 7 or 8 depositions that I previously asked for. I added Gensler because he testified, and he testified, at least it wasn't some, he didn't never said he didn't know anything about MMTLP. And, and so JR and I have had discussions about what my anticipation would be about the response to discovery. And I'm obviously not going to say until afterwards what I expect or what I would do, but it's interesting to see because Fidelity's counsel, who was the counsel that Ham happened to educate at some point in time, per his statements, is being super aggressive. And I'm sure they will object to all discovery. And I've made a stink about the selection of the arbitration panel. And we have a hearing. Our first hearing is October 3rd. So I will have more information certainly then. I will get more, response from the other side. I think I've filed so far in the arbitration. We haven't done really much, 16 pleadings so far in the arbitration. But it's interesting to see, again, if the arbiters permit me to depose somebody like Gensler, somebody like Dratty, somebody like Johnson, somebody at a lower level, it may yield information that would really be helpful to us. And the documents themselves, obviously, I want share information and I want the share lending information, because now it appears that the share lending information might demonstrate the motivation and intent as to why they do what they do. So that's mine. Today's September 25th. Our hearing, 24th. Our hearing's the 3rd. It's about 10 days off. And be interesting. Interesting because I haven't been too nice to the prospective, to one prospective arbiter. I've not been particularly nice. It puts him in a difficult position, which I like. And it was not his fault to be put in that position. It was really FINRA's kind of error, but we shall see how it works out. Other than that, I'm not aware of any movement in any of the other cases, ongoing cases.
I think Alan posted something a couple of days ago that they are gearing up for a pre-discovery meeting.
Okay.
Which is a procedure in which all the parties sit down and the judge sits down and they kind of plan out how discovery is going to go. Now, I will tell you, I have not talked to Alan in weeks. I have no idea if they've actually filed motions to dismiss against him, so I don't know. He does, I believe he has the president judge in his district. So one of the things that I talked to him privately about back, I want to say it was maybe June, was it sounds like he's got a very efficient judge, that the judge is, what I would call very task oriented and is keeping things on track. So that's a positive for him. He would probably get a lot of leeway because he's a pro se petitioner. But I don't know if opposing counsel has filed motions to dismiss in his claim.
I think so, but I think haven't been heard yet or pending. I was going to say in mine, we did it. I think I asked for it like day one, but basically the way it's set up is it's discouraged until the pleadings are set.
Right.
So in other words, the pleadings being set being the complaint's challenged and survives, and the logic being why do all the discovery if the complaint's not going to survive.
Right.
So I think that's where he is in terms of that That discovery conference, the way it works is the parties get together, as you say, they prepare a document.
Right.
They submit it to the court. It has like scheduling orders and what people are going to do. They present it to the court. The judge will either sign it or not sign it, can conduct a hearing. I know in my case, what happened was we were in the middle of a bunch of motions to dismiss. The judge took the order, the scheduling order. It's I think a Rule 26F. We all know that, of course. Rule 26F scheduling order.
Yeah, now I remember.
Yeah, we filed it. The judge accepted it and then continued the hearing on the scheduling, then granted the motion to dismiss, and we never actually had the hearing on the scheduling of the discovery because I wanted it from day one. But that's probably what's going on. They may give them more. To clarify, it's not just being a pro se. So pro se means you're not being represented by counsel. In state court, at least in California, it's a pro per, slightly different. Only Latin words we ever know. So yeah, so I believe like a pro se, like a real pro se, like Alan, who's not an attorney, that they will bend over.
Oh yeah,
and a pro se like Richard Hoffman, who's an attorney, no. He will not. They will not. They won't treat me any different than anybody else, and they won't.
I was a law student when I represented myself, and I didn't get shit. I got yelled at.
Yeah, I don't think they give you any particular email. Let's ask this. I'm going to put this one up because it's an interesting question. Oh,
you are very informative, you guys. I know you guys are not financial advice, but I would not take your advice if my balls were on the chopping block. I would not take your advice.
Nice.
I think that's a compliment, Chris from New York City. and if you're, never mind. Could an unredacted version of Howard's FOIA emails with the isn't there enough evidence to subpoena the recipient of the email at the SEC? Bet you it's Gigi. Well, whether we think there's enough evidence or not, there's no pending litigation that's gotten to the point where a court could issue a subpoena at this point. And let's take a step back because this is a really good opportunity to kind of educate people on the process of a hearing. You know, all of these hearings, you know, yours was dismissed. It was dismissed on the pleadings. So you filed a complaint. They filed a motion to dismiss that complaint. They won, your case was booted out. Same with Rosa. She filed a complaint. They filed a motion to dismiss. She amended the complaint. They filed an amended motion to dismiss, booted out. Hands of Steel. I know he's filed a complaint. I don't know where the other side is in terms of filing their motion to dismiss. So what we've seen so far is these cases aren't making it far enough along in the procedure for a court to say it's time to issue a subpoena because someone isn't providing what they need to. So while yes, it is, the information could be subpoenaed, no court has been at that point where they can use the subpoena power to issue a subpoena to request that information.
Yeah. And by the way, I thank Chris for his input. I agree. And if you were watching when we started, I don't know if you were watching. I don't know if you watch us weekly, but we always start off with, don't rely upon anything we say and do your own due diligence. And I agree with you, by the way. I wouldn't hire a lawyer off of the internet or off of YouTube, unless that lawyer was really good or they were practicing an area I needed them, or they were in my jurisdiction, or I knew them, or there might be like 50 factors. So your statement was funny, I found, because it was so simplistic. But I appreciate I do appreciate you watching, and I do agree with you that everybody should do their own due diligence, and they have to be confident in whatever they do, because we've all been in the position, if you're not confident, when the shit hits the fan and your security gets knocked, it's tough to hold on. So you really got to be.
Let's make a point here. We're not here to offer advice. We're here we're two guys having a conversation and trying to educate people based on what the research that we've done. I mean, we talk about stocks, but we talk about stocks that we already have positions in. Now, the YouTube that we had last week, neither one of us held positions in that. We thought it was interesting from the toxic loan perspective and what this particular corporation had done, because there's a huge misunderstanding in convertible loans and what we term as toxic lending, and that's what Mark specializes in. So we thought it was a unique opportunity to bring that individual on and share his perspective on it. But definitely, I mean, this is not. And Chris, I'm picking on you, but I appreciate the comment. We're not here to offer advice, and I'm glad that you wouldn't take our advice if your balls were on the chopping block. But that would be a problem if that was the situation you were in, and I would strongly advise you to get counsel.
Yeah, and anybody, by the way, it makes a difference also if you have a need for I don't know if we even talked about this ever. If you have a need for counsel, it has to be in your jurisdiction. They should be, they should know the law of your jurisdiction. They should know what your issue is, and they should be capable of handling the issue. So all that should be taken into account. So that's everybody, and that's any legal dispute involving anybody, and it applies to any security that anybody's thinking about buying. Because again, you got to be sold on it, because if you're not, you're going to bail, because that's what happens, because it's not easy to do.
Of the company. Here's a good question, and we talked about this for a little bit at the beginning, and I actually talked about this with another individual over the weekend. It's Ding Dong's question. Put that one up, Richard. Can we FOIA the SEC in regards of Citadel to find out the name of the companies that were naked shorted? I think you can. The investigation is over, so they can't rely on Exemption 7A. So yes, I think that information could. Well, let me take a step back. You can FOIA and request anything. Whether or not they respond is entirely different. But I think this is something that someone should do, is submit FOIAs for the tickers that were naked shorted by Citadel. And I'm sure people are. I know one person is, because I talked to him about it this weekend.
Yeah, and I would say, also Goldman Sachs got hit also. So if you had an account at Goldman Sachs, you could certainly also make a FOIA request as a client of Goldman Sachs for the same information, whatever nonsense they were involved in. Because we were saying, JR was saying this is not a case that there's a dispute. These are cases where the guilty parties have acknowledged the guilt. So they're not even contesting it. So we're not even arguing about that kind of stuff.
And the fact that they've settled it tells me the investigation's over.
Yeah. Agreed.
Smoked
turkey
and being super tasty. No.
Anyway, anything else you want to talk about MMTLP? So the arbitration's ongoing. We'll obviously keep you apprised. If there's anything else that goes on that happens on a weekly basis, we'll obviously keep you apprised. We kind of try to bring up stuff during the week. Beyond that, I think that's kind of about everything for this evening.
That was almost 2 hours, Richard. Almost 2 hours.
Anyway, to all those out there who followed, who commented, who watched, who listened, we really appreciate it. To any of those additional who comment in the future, who offer suggestions, who offer who's the worst regulator of the week, feel free, and thank you for joining us. We'll be back next week. And by the way, if any of you have guests that you have contact with that you think we might be interested in interviewing, feel free to suggest it or reach out or whatever. We'll be happy to kind of widen the knowledge base, and we're always interested. So anyway, thank you again, everybody, and thanks, JR, for a great evening. And we'll talk again soon. And to all you out there, have a great evening. Everybody be well and take care, and see you next week.
See you next week, folks.